Breaking news from the state of Georgia, where that state's Supreme Court has blocked 4 election denier rules passed by a right-wing election board in 2024. This is good news for voters going into the 2026 midterms. Welcome back to Democracy Docket. I'm Marc Elias.
And I'm Paige Moskowitz. Let's get started.
You know, Paige, here we are in the middle of June, and the Georgia Supreme Court, of all places, in a unanimous ruling, has struck down 4 rules passed by that state's far right-wing state election board, saying that it exceeded the authority in passing these rules. And this is good news for voters and a huge setback for the Republican Party.
Right, Mark. Now, to jog everyone's memory, late last summer, the Georgia State Election Board, which is a 5-member body in charge of creating rules to ensure uniformity across the state when it comes to the election, started approving new rules that threatened to delay the certification of Georgia's elections. Now, there was a handful of rules they passed. One of them involved hand counting all the ballots cast in the election. One of the most concerning rules would have allowed members of the election board to delay certification by doing their own investigations into the election. Now, Mark, this whole situation drew a lot of national attention, and it kind of started because Trump himself, while he was a candidate at the time, called out 3 members of the Georgia State Election Board and called them pit bulls for transparency. He highlighted them by name, and it was very unusual for a presidential candidate to name 3 state-level election officials like this, who are supposed to be more behind the scenes doing nonpartisan work to ensure uniformity in the state.
Paige, you're exactly right. And it set off a lot of concern, not just in Georgia, but nationwide, that we were going to see election subversion after the 2024 election. Effectively, Republicans would be refusing to accurately count ballots and to certify the results. Now, this is something that you and I did a lot of reporting on, not just in 2024 when this was all going on, but going all the way back to 2022, where we actually saw some Republican counties around the country tried to refuse to certify election results. We had also seen that, by the way, by Donald Trump trying to convince election boards in Michigan in 2020. But this took on a bit of a life of its own in 2022. And then in 2024, here was the Georgia State Election Board passing these rules, particularly the reasonable inquiry rule and the so-called examination rules, which seemed to be geared to allow these right-wing members of these county boards to simply say, I don't trust the election results. I want more information. I'm not going to certify the election results. Now, that wound up not coming to pass because Donald Trump obviously won the state of Georgia, and it didn't come to pass in other states where we worried about this as well. But as we look forward to 2026, this has continued to loom really large, and it is great news to see that these were struck down along with the hand count rule, which was another way, again, that things could be delayed. And I think a lot of people were surprised that this was not just a favorable ruling, before a relatively conservative state Supreme Court, but actually a unanimous ruling of that court.
Right, Mark. And to give background on the composition of Georgia's state Supreme Court, it is a 9-member court. There are currently 8 members. However, there is a vacancy on the court. Georgia elects its justices through statewide nonpartisan elections. However, 7 of the current 8 members of the court initially got their seats by appointment from the governor. They were filling vacancies. It was Republican governors who appointed 7 of these currently 8 sitting members of the court. So you would assume maybe they would side with Republicans in this manner. In fact, it was the RNC who appealed this case to the state Supreme Court. However, the Georgia Supreme Court blocked these rules from going into effect shortly before the 2024 election. So these rules weren't in effect then, and they delivered a final strike down of them now.
Yeah, and look, this is going to have repercussions for weeks and months to come. So this will have reverberations not just in Georgia and around the country. And look, this is the reason why I started Democracy Docket in 2020. It's to get you this kind of breaking news and analysis. And this information is never more important than right now with everything that is going on with voting and elections, but also Donald Trump and his efforts to subvert democracy. So please make sure you're subscribed to this YouTube channel. Click the subscribe button right now. Hit the bell to make sure you get alerted whenever there's new content, but also make sure you're subscribed to Democracy Docket's free and premium newsletters. The link to all of that is above and in the description below. Paige, we talk about this as an important case in Georgia, but this really is an important case around the country. I mean, Cleta Mitchell, a name we often talk about, she was a big proponent of some of the changes that were pushed here. She was a big proponent of the members of the board here that pushed these rules. This was a big nationwide effort, and there's no reason to believe that that is going anywhere or any less robust as we head into the future.
Marc, 100%. We saw, as you said, Cleta Mitchell's group get involved here. We saw other groups support these kinds of rules. And we've seen groups around the country, try to urge their state's election officials to change the way rules are enforced. But I actually think what the Georgia Supreme Court said here was really important. 5 rules were appealed to the state Supreme Court. They struck down 4 of them. And they said that the state election board can pass rules to implement and enforce the election code, but it cannot go beyond, change, or contradict the election code. That feels like something we're also seeing mirrored in these Trump accountability lawsuits across the country, of judges saying that executive agencies or different boards of states or the federal government can change rules, but only within the law. And it's ultimately up to lawmakers to be the ones themselves to implement these sweeping, broad changes.
Yeah, you may remember that when this lawsuit was filed, there were a series of lawsuits filed to challenge these rules. When this lawsuit was filed, people perked up because it was actually a conservative organization that was behind these challenges, using a conservative doctrine, a traditionally conservative doctrine, the so-called non-delegation doctrine. The idea is that there are certain powers inherent to a legislature, whether it's the state legislature in Georgia or it's the Congress at the federal level, that these are their powers, and that federal agencies in the case of Congress and state agencies in the case here can't simply run with vague language and do whatever they want, that there are certain things that only the legislature can do, that they actually can't delegate at all. But even when they do delegate, the delegations need to be well spelled out and be fairly narrow. This is something that conservatives spent a lot of time during the Biden administration developing as a legal theory, and got some traction in the U.S. Supreme Court with the so-called major questions doctrine, among other cases. And now we are seeing here in Georgia this being used to block voter suppression and election subversion laws. And as you point out, that same doctrine, that same theory that basically that cabins the ability of executive branch agencies and personnel to stray too far away from the text that Congress has passed, and to exercise power even within that text that really is only left to Congress. We have seen that become actually now a tool to hem in Donald Trump. So there is a definite connection here between what we have seen going on at the federal level and going on in the state level. It is worth, since we keep saying that 4 of the 5 rules were blocked, it's worth saying a little bit of something about the one rule that was not blocked here.
Right. The one rule that the state Supreme Court upheld required video surveillance of drop boxes after the polls closed each day.
Yeah. And, look, I think this is a bad rule. I don't think that this rule should have been upheld, on its as a matter of its merits. In other words, I think this is all silly. You and I've talked about, the Republican absolute obsession with drop boxes, is just inexplicable. But honestly, of all of the rules, this one probably was set to do the least damage when you compare it to the ones that really were aimed at delaying certification, preventing perhaps certification, creating a lot of confusion after the fact. So, ideal, no, but it could have been a lot worse there. It's also worth pointing out, Paige, that along the way in this opinion, the Supreme Court of Georgia rewrote essentially its standing jurisprudence. In other words, what does it take to have standing to bring a challenge? And it's very interesting because they deviated from the federal standard. And I don't know exactly why. I don't know if they felt that the federal standard just doesn't accord with the state constitution, but it for sure created a theory of standing which is much more voter friendly than where the federal courts have been going. It basically said, that you don't necessarily need to prove, which you do in the federal courts, injury in fact, but you just have to show that there is a protected constitutional right. And it says the right to vote is a protected constitutional right. In fact, they wax somewhat eloquently about the importance of the right to vote under the Georgia Constitution. So again, I don't want to get too far ahead of ourselves in saying that somehow this state Supreme Court is not still a very conservative court. It is, but it is notable here that it both struck down these rules, it affirmed essentially voter standing, and if you go back in time, you and I did a video now a couple of years ago when the state Supreme Court failed to get involved, failed to overturn a lower court decision that meant more early voting. I think it was on the Saturday after Thanksgiving in the Senate race, special election Senate race a couple of years ago. So, at least we're seeing that, if not a trend, we're seeing that the Georgia State Supreme Court is certainly attentive to voting rights and will rule in favor of voting rights under the right circumstances.
Marc, it's a very interesting situation developing out of Georgia, and we can't predict a lot of things about courts and litigation, but you can almost guarantee that there will be lawsuits in Georgia when it comes to the 2026 midterms and the 2028 election. And you can be sure that Democracy Docket will be here to track and report on them and to keep all y'all informed about what is happening to the state of voting rights in courts, not just in Georgia, but around the country.
Yep. So please make sure you're subscribed to this channel, hit the button, also get alerts when there's new content, but also take a second, click on the link to become a premium or free member of Democracy Docket to get all of the news, information, and analysis that you need to stay informed. We'll see you next time.